A unanimous federal court decision just dropped that could change everything you thought you knew about suppressors and the NFA, and the Department of Justice did something nobody saw coming. They completely reversed their position on whether your suppressor is protected by the Second Amendment. Quick question before we continue. Are you subscribed yet? Because what I'm about to reveal could save you thousands of dollars and keep you from accidentally violating federal law. The legal landscape is shifting faster than ever. And if you're not getting these updates, you're flying blind. Hit that subscribe button right now so you don't miss what happens next. Here's what just happened. On December 9th, 2025, a 3-judge panel from the Fifth Circuit Court of Appeals issued their third and final opinion in a case called United States versus Peterson. Now I know what you're thinking. Another court case. Another loss for gun owners. But hold on, because this one is different. And when you combine it with what the DOJ just admitted, everything changes. Let me back up and explain the full story from the beginning. George Peterson owned an unregistered suppressor. Law enforcement raided his home and business, found it, and charged him with violating the National Firearms Act, that 1934 law that has shaped suppressor regulation for decades. Peterson fought back. He argued that the Second Amendment protects his right to own a suppressor without excessive government restrictions. Now, here's where things get interesting. This case went through 3 different versions of the same opinion. 3 separate times, the court had to rewrite its decision. Why? Because the Department of Justice kept changing its position. Under the Biden administration, the DOJ argued that suppressors are not arms at all. They claimed suppressors are merely accessories, like scopes or slings, and therefore not protected by the Second Amendment. End of story. But then something unprecedented happened. When President Trump began his second term, the DOJ filed a new brief in June 2025. And in that filing, they acknowledged something significant. They stated that suppressors do enjoy some level of Second Amendment protection. Let that sink in. The same Department of Justice that has defended the NFA for decades admitted that suppressors are connected to constitutional rights. Now, quick legal note. This is educational information, not legal advice. Always consult an attorney for your specific situation. My goal is to break down what's happening so you can make informed decisions. So, yes, the DOJ changed course. They went from saying suppressors have zero constitutional protection to acknowledging they fall within the Second Amendment's scope. But they didn't go all the way. They continued arguing that the NFA's requirements, registration, fingerprints, background checks, approval, are not overly burdensome and therefore remain constitutional. The Fifth Circuit panel ultimately agreed with this revised DOJ position, but here's what most people are missing. The court made its ruling extremely narrow. They ruled only on Peterson's specific case and emphasized, repeatedly, that their decision does not settle the broader constitutional questions. In fact, they wrote that they do not foreclose the possibility that another litigant could successfully challenge the NFA's requirements. Think about that. A unanimous federal appeals court effectively signaled that the door remains open. Peterson lost because he did not build a strong enough record. He admitted he never attempted to comply with the registration process. He simply possessed an unregistered suppressor. The court essentially said, you can't argue the system is too burdensome if you didn't even try to go through it. That distinction matters. If you're finding this helpful, imagine what you'll learn in the next breakdown where we discuss the key mistakes gun owners are making right now that could cost them everything. Make sure you're subscribed so you don't miss it. But there's more happening that you need to understand. The National Firearms Act has long been defended as a tax law. For decades, the $200 tax stamp was central to that framework. Then, on January 1st, 2026, something major changed. The $200 tax stamp for suppressors and other NFA items was eliminated through federal legislation. Gone. $0. At first glance, that sounds like a huge victory. But here's the reality. The registration requirement remained intact. You still need ATF approval. You still submit fingerprints and photos. You still pass a background check. You still wait for processing. The financial barrier dropped. The regulatory structure did not. And that's where things become even more consequential. Now here's where everything starts to accelerate. Multiple lawsuits are now challenging the entire NFA framework. The most prominent is Silencer Shop Foundation versus Bureau of Alcohol, Tobacco, Firearms, and Explosives. Their argument is straightforward but powerful. If there's no tax, then the NFA is no longer functioning as a tax statute. And if it's not operating as a tax law, then Congress cannot rely on its taxing authority to justify regulating suppressors under that framework. In other words, they're arguing that the constitutional foundation the NFA was built on has shifted. For decades, the government defended the NFA as a tax and registration scheme. Courts upheld it largely under Congress's taxing power. But if the tax component disappears, what remains? That's the core question now being litigated. And the DOJ's response in early 2026 introduced another twist. In defending against the silencer shop lawsuit, the Department of Justice argued that suppressors are dangerous and unusual weapons. Stop there for a moment. In the Peterson case, the DOJ acknowledged suppressors fall within the Second Amendment's scope. In the silencer shop case, they argue suppressors can be treated as dangerous and unusual. Those positions are difficult to reconcile. Either suppressors qualify as protected arms, commonly possessed for lawful purposes, or they fall outside the Second Amendment entirely. The government cannot easily maintain both theories without creating tension in its legal arguments. This matters because of the Supreme Court's 2022 decision in New York State Rifle and Pistol Association versus Bruen. That decision changed the framework courts must apply in Second Amendment cases. Under Bruen, the government cannot simply argue that a regulation promotes public safety or that an item is dangerous. Instead, the government must demonstrate that the regulation is consistent with the nation's historical tradition of firearm regulation. That historical analysis is now the controlling standard. So the question becomes, is there a historical tradition of requiring registration and government permission to own suppressors? Suppressors did not exist at the founding. When they were later invented, they were widely available for decades without federal registration requirements. That historical record is now central to ongoing litigation. This is why legal observers say the NFA is facing its most serious scrutiny in generations. Now let's be clear about where things stand today. The Peterson decision did not invalidate the NFA. The tax elimination did not eliminate registration. Suppressors still require ATF approval under current federal law. But the legal arguments surrounding the NFA are evolving rapidly, and more cases are moving through the courts. The National Rifle Association has filed Bruen versus ATF. The Second Amendment Foundation is involved in multiple challenges. Gun Owners of America is actively pursuing litigation. Several cases are building detailed factual records, documenting wait times, administrative delays, denials, and procedural burdens. Why does that matter? Because the Fifth Circuit made something clear in Peterson. The outcome may have been different if the record had shown concrete evidence that the process substantially burdens the exercise of Second Amendment rights. In other words, future litigants are now being given a roadmap, demonstrate the practical burdens, document the delays, show how the process operates in reality. If a plaintiff can present a comprehensive factual record demonstrating that the system meaningfully interferes with the right to keep and bear arms, courts may be required to analyze that under the Bruen historical test. And that analysis could look very different from prior decades. So where does this leave gun owners right now? First, understand that the law has not disappeared. Even though the $200 tax is gone, federal registration requirements remain in effect. Possessing an unregistered suppressor still violates federal law. Second, recognize that ongoing litigation could reshape the regulatory landscape. But until courts issue final rulings, existing requirements must be followed. Third, stay cautious about online claims. There is significant misinformation circulating. Some claim the NFA is effectively dead. Others claim suppressors can now be purchased without any federal process. Neither of those claims reflect current federal law. The regulatory framework is being challenged. It is not yet dismantled. But we are clearly at an inflection point. The DOJ's position shift signals awareness that older arguments may not withstand the Bruen framework. Courts are issuing narrow decisions rather than sweeping rulings, and multiple cases are advancing with more carefully constructed records. For the first time in decades, the structure of the NFA is being re-examined through a modern constitutional lens, and that makes the next phase critical. Let's walk through what this moment actually represents. For over 90 years, the National Firearms Act has operated with relatively stable judicial support. Courts routinely upheld it. Challenges rarely gained traction. The framework seemed untouchable. That stability is now being tested. The Peterson decision shows that federal appellate courts are willing to analyze suppressors within the Second Amendment's scope. Even though Peterson lost, the court did not slam the door shut. Instead, it emphasized the narrowness of its ruling and left room for future challenges built on stronger records. That language matters. When a unanimous panel explicitly states that another litigant could potentially succeed, it signals that the constitutional question remains unsettled. Now, layer onto that the removal of the $200 tax. For decades, the NFA's tax component provided a key constitutional justification. Courts often pointed to Congress's taxing authority as a supporting basis for the law's structure. With that financial element eliminated, litigants are now asking whether the remaining registration regime can stand independently under the Constitution. That is not a minor technical adjustment. It shifts the analytical ground beneath the statute. Meanwhile, advocacy groups are doing something different than in past challenges. They are not relying solely on abstract constitutional arguments. They are compiling data. They are documenting processing delays. They are collecting evidence of extended wait times. They are tracking administrative backlogs. They are building factual records designed to demonstrate real-world burdens. Why? Because under Bruen, courts look at history. But they also examine whether modern regulations align with historical tradition. If plaintiffs can show that modern requirements impose significant barriers without historical analogs, courts must confront that mismatch. This is why the Fifth Circuit's comment about record building is so important. Peterson's case did not include detailed evidence about wait times, procedural obstacles, or systemic delays. The court noted that absence. Future litigants are unlikely to make that same omission. Now consider the broader judicial landscape. If different circuit courts begin reaching different conclusions about suppressors or NFA registration, a circuit split could emerge. Circuit splits often increase the likelihood of Supreme Court review. The Supreme Court has thus far avoided directly confronting the NFA in a sweeping way. But evolving lower court decisions, combined with shifting government positions, may eventually force the issue. If the court grants review in a suppressor case, it would apply the Bruen framework. That means the government would need to point to historical analogs for registration and permission requirements related to similar arms. Whether such analogs exist, and whether courts find them persuasive, would become central to the outcome. Until then, everything remains in motion. The Peterson ruling leaves the door open. The DOJ's revised position acknowledges constitutional protection while still defending regulation. The tax elimination removes one long-standing pillar of the statute's defense, and multiple cases are advancing through federal courts. This is not the end of the NFA, but it may represent the most significant period of constitutional reevaluation the statute has faced in modern history. For individuals considering suppressor ownership, the practical takeaway is straightforward. Current federal registration requirements remain enforceable. Approval through the ATF is still required. Compliance with existing law is essential unless and until courts issue definitive rulings altering that framework. At the same time, it is equally important to recognize that the legal environment is not static. Arguments that once failed may now receive renewed scrutiny under the Bruen historical test. Government positions that once appeared firm are now being recalibrated. And courts are signaling that broader constitutional questions remain unresolved. This combination of factors creates momentum. Not certainty, not immediate change, but momentum. So here's the bottom line. A unanimous federal appeals court issued a decision in United States v. Peterson that, while narrow, left the constitutional door open. The Department of Justice revised its position and acknowledged that suppressors fall within the scope of the Second Amendment, even while continuing to defend the NFA's regulatory structure. The $200 tax component of the NFA was eliminated beginning January 1st, 2026, and multiple lawsuits are now challenging what remains of the statute under the Supreme Court's Bruen framework. Each of those developments, standing alone, would be significant. Together, they mark a pivotal moment. For decades, the NFA operated with relatively little constitutional uncertainty. Courts upheld it. The government relied on long-standing precedent. Challenges struggled to gain traction. Now the analytical framework has changed. Under Bruen, courts must evaluate whether modern firearm regulations align with the nation's historical tradition of regulation. That test is reshaping Second Amendment litigation nationwide, and suppressors are now part of that evolving conversation. The Peterson court made clear that its decision was limited to the specific facts presented. It emphasized that future litigants could potentially bring stronger, more developed challenges. The DOJ's shift demonstrates that even the government recognizes the need to recalibrate its arguments under the new constitutional standard. And the removal of the tax element has prompted renewed debate over the NFA's structural foundation. At this stage, no sweeping judicial decision has dismantled the NFA. Registration requirements remain in place. ATF approval is still required. Federal compliance obligations remain fully enforceable. But the legal debate is no longer settled in the way it once was. The courts are actively examining these issues. Advocacy groups are building records. Litigation is progressing. And the possibility of eventual Supreme Court review cannot be dismissed. If the Supreme Court were to grant review in a suppressor case, it would likely apply the Bruen historical tradition analysis directly to the NFA's registration framework. That would represent the most consequential examination of the statute in generations. Whether that occurs, and how the court might rule, remains to be seen. For now, the key takeaways are clear. The Peterson decision was unanimous but narrow. The DOJ acknowledged Second Amendment protection for suppressors. The $200 tax is gone. The registration requirement remains. Multiple constitutional challenges are advancing. The legal landscape is shifting, not collapsing overnight, not disappearing, but shifting. For the first time in many years, the National Firearms Act is being scrutinized under a constitutional test that did not exist when prior precedents were decided. That alone makes this moment significant. Staying informed matters. Understanding what has changed and what has not matters. Recognizing the difference between ongoing litigation and final rulings matters. The courts are re-examining long-standing assumptions. Government arguments are evolving, And the next chapter will depend on how these cases develop in the months and years ahead. This is a turning point, not a conclusion. And as the legal process continues, clarity will come through court decisions, not speculation. For now, the message is simple. The debate is active. The litigation is real. The outcome is not yet written.